All right, welcome everyone. If you're getting ready for your constitutional law exam, you know there's one topic that's always a bit of a beast, the power of the NPSC. So this explainer is all about cutting through that complexity and giving you a super clear framework you can use to ace your revision.
So let's jump right in with the big question. Who really has the final word on Hong Kong's constitution? I mean, this question is the absolute core of the one country, two systems framework. It's really all about the dynamic, sometimes tense, relationship between Hong Kong's courts and Beijing's top legislative body, the National People's Congress Standing Committee, or as we all know it, the NPSC.
For your exam, the best way to think about the NPSCC's power isn't as just one big thing. Instead, think of it as a set of distinct tools. So that's what we're going to do today. We're going to unpack three key mechanisms, or toolkits, that the NPSCC has, and we'll link them to the essential cases you absolutely need to know. Okay, let's start with mechanism number one. This is the most formal, kind of by-the-book process. It's the official channel laid out right there in Article 158 of the Basic Law, where Hong Kong's highest court, the Court of Final Appeal, or CFA, can actually ask the NPSC for an interpretation.
So when does the CFA have to make this request? Well, the court itself came up with this handy three-part test. For referral to be mandatory, first, the case has to be about a provision concerning Beijing's responsibility or the relationship between the central government and Hong Kong. Second, interpreting that provision has to be genuinely necessary to decide the case. And third, there just has to be a plausible or arguable case for referral. You have to know these three conditions for your exam. They are absolutely crucial.
Now, here's where it gets really interesting. And honestly, this is a fantastic point to make it an essay. Even though this formal process has been around since 1997, the Court of Final Appeal has only actually used it once, just one single time.
And that one time was back in 2011, in a case that involved the Democratic Republic of Congo. The central issue was state immunity. The big question was, should Hong Kong courts follow mainland China's policy of absolute immunity, which means you can't sue a state for its commercial dealings? Or should they stick with their own common law tradition of restrictive immunity, which says you can?
And wow, the court was split right down the middle on this. The majority said, hey, this touches on foreign affairs. That's a central government matter, so we have to refer it. But there was a really powerful dissent that argued this was purely a question of common law, something the Hong Kong courts not only could decide, but that they had a duty to decide for themselves. In the end, the majority won. The question went to Beijing, and the NPSCC's response was fast and crystal clear. It declared that China's policy of absolute immunity is the policy in Hong Kong, and that courts must give effect to it. And pay attention to the style here. It wasn't a long, reasoned common law judgment. It just stated the true meaning of the law. Okay, let's move on to this second mechanism. And this one is a whole different beast. It's way more powerful. This is the NPCSC's plenary, or you could say absolute power to interpret any part of the Basic Law whenever it wants, on its own initiative, without even waiting for a Hong Kong court to ask. The most famous and probably the most dramatic example of this power was the 2016 oath-taking saga. You might remember this. After a local election, several newly elected legislators changed the words of the official oath during their swearing-in ceremony, and it just kicked off this massive legal and political firestorm. And here is the absolute crucial point in the timeline. The Hong Kong government took the legislators to court. But, and this is key, before the local court could even issue its judgment, the NPSCC just stepped in. It issued its own interpretation of Article 104, which is the part of the Basic Law about oath-taking. It didn't wait for the judicial process in Hong Kong to finish. Now, this interpretation wasn't just a simple clarification. No way. It basically added new, very strict rules. It said the oath must be taken sincerely and solemnly, that any funny business meant you were immediately disqualified, and, this was a big one, no second chances. It even added a new requirement that you had to uphold the Basic Law just to be eligible to run for election, which wasn't in the original text of Article 104 at all. And this case just perfectly highlights the clash of legal cultures, right? On one hand, you've got the CFA's common law approach, which is all about looking at the text, the context, and the purpose to interpret the law as it's written. On the other, you have the NPSCC's legislative interpretation, which is about declaring the true meaning or legislative intent, and in doing so, it can effectively add to the law. All right, on to our third and final toolkit.
This one's a bit different because it uses legal instruments that aren't technically interpretations of the Basic Law in the same way.
So first we have something called NPCSC decisions. A really key example is the decision that gave the green light to the high-speed rail co-location plan. This created a mainland port area right inside the West Kowloon train station, where mainland law, not Hong Kong law, is applied. This was a huge constitutional step, and it was done through a decision, not an interpretation.
And second, and this is probably the most significant development in recent years, we have the national security law. This is a totally separate national law that's been applied in Hong Kong. And the crucial part, Article 65, says that the power to interpret this law belongs only to the NPSC. This creates a brand new pathway for influence that completely sidesteps that whole Article 158 process we talked about earlier.
We saw this new mechanism play out in the very high-profile case of media tycoon Jimmy Lai. He wanted a senior lawyer from the UK to represent him in his national security trial. The Hong Kong courts, all the way up to the Court of Final Appeal, said, yep, that's fine, he can do that.
But in direct response to that final court ruling, Hong Kong's chief executive did something nobody had ever seen before. He asked the NPSCC for an interpretation, not of the Basic Law, but of the national security law itself on this very question of overseas lawyers.
And the NPCSC's interpretation came back. It clarified that deciding whether an overseas lawyer can be in a national security case, well, that's not just a standard call for the courts to make. Instead, the final decision rests with Hong Kong's chief executive and a body called the Committee for Safeguarding National Security. And, importantly, that committee's decisions cannot be challenged in court.
Okay, we've gone through the 3 toolkits. Let's pull this all together and consolidate it into a really clear framework you can take straight into your exam revision. Here it is. This is your money slide, your revision cheat sheet. Toolkit 1, Court-Requested Interpretations under Article 158. The key case is DRC and state immunity. Toolkit 2, Proactive Interpretation using its plenary power. The big example there is the oath-taking saga. And Toolkit 3, Other instruments like decisions or the NSL. Think of the collocation plan and the Jimmy Lai case. So if you're looking for the big picture, the main thesis for your essay, it's this. Over time, we have seen a clear shift. The NPSCC has moved from being a more reactive body that could be asked for an opinion to a much more proactive one that actively steps in to direct legal outcomes and even create new legal rules. And that leaves us with a final thought, the kind of big picture question you should be tackling in your essays. Nobody doubts the NPSCC's constitutional power is supreme, but the methods it uses to exercise that power have clearly grown and changed. So the ultimate question is, as all these different mechanisms become more common, what does that mean for the long-term future of judicial autonomy in Hong Kong's common law system? Good luck with your revision.